Assalamualaikum. My name is Diyana Athirah and I will be presenting regarding part A of the assignment of the arbitration. And firstly, I would like to address that this issue focus heavily on determining the governing laws for both main contract and the arbitration agreement itself. And the primary question that we must answer is this: does the Malaysian law govern the main contract and the arbitration agreement, given that the vast majority of the operational obligation, regulatory approval, and environmental risk physically tied to Malaysia? Or does the contractual choice of the transnational law and the English law will override this domestic connection? So firstly, we need to look at the factual snapshot. First, where the clause 26, it chooses the transnational commercial law for the main contract. And clause 25 sets the arbitral seat to be sit in the London based on the LCIA rules. And crucially, in the arbitration clause itself explicitly states that the arbitration agreement shall be governed by the English law. Firstly, we need to analyze that we must look at the legal framework. So under the section 18 subsection 1 of the Malaysian Arbitration Act 2005, the doctrine of the separability is strictly mandated, and this means that the arbitration clause is treated as independent agreement, which is completely separate from the underlying contract. Therefore, the choice of law for the main contract does not automatically dictate the law of the arbitration clause. Next, under Rule 16.4 of the LCIA rules, this law of the arbitral seat governs the arbitration agreement by default, unless the party also agreed otherwise in writing. And lastly, the rule to be used is Section 9A of the Malaysian Arbitration Amendment Act 2024, where this amendment was introduced to clear the jurisdictional battle by defaulting the law of the seat when a choice is absent. Section 9A, subsection 1, fiercely protects the party autonomy if an express choice is present. And to discuss about the case law, in the famous case of the Sulamerica, the English court established the substantive law presumption, and by this case, it ruled that in the absence of the explicit choice of law of the arbitration agreement, the law of the main contract is a strong indicator of what parties intended. But we must ask, does the Sulamerica apply to our client's fact? So by applying this principle of this case, firstly, regarding the main contract, Nusantara Resource cannot successfully argue that Malaysian law completely replaced the chosen law simply because the project takes place in Malaysia. And under the principle of the party autonomy, we must note that the explicit choice of transnational commercial law in the clause 26 will stand validly. However, it is important to note that there is a major catch that benefits our client in this question. Firstly, the contract explicitly contains a provision requiring that all operational activities to comply with the host state law. Therefore, while the interpretation of the contract falls under transnational law, we must also take note that the physical performance of the operation is strictly bound by the mandatory Malaysian environmental, labour and public safety law. Now, by applying the rules of the arbitration agreement, this is where the Nusantara's argument face the toughest hurdle, because the contract explicitly draft that the arbitration agreement shall be governed by the English law. Uh, from this statement, we have an express choice, because when the express choice exists, the court completely bypassed the Sula America presumption and also Section 9A subsection 2 defaults. And those rules are only used to find an implied law when the contract is silent. And by this mean, the contract is not silent, because the express choice of English law stands on its own feet, which heavily enforced by the selection of the London as the seat and LCIA Rule 16.4. So to summarize our finding and legal advice for the Nusantara resource, the main contract is validly governed by the transnational commercial law, but its operational execution is explicitly legally subjected to the mandatory Malaysian domestic law. And for the arbitration agreement, it is strictly governed by the English law, and this is because it is unambiguous express wording in the contract, which further solidified by the London being the chosen seat. So finally, our direct answer to this issue is no, because Malaysian law does not govern the arbitration agreement of the main contract itself, despite the physical, environmental, and regulatory connections to Malaysia. And the express choice that made during negotiation legally override those physical connections. So basically, Nusantara cannot fight global minor on this specific choice of law ground. Instead, as we move to the part B, C, and D of our defense, Nusantara's strongest strategic move is to pivot away from the choice of law, and instead of focusing heavily on how the mandatory Malaysian public policy overrides the contract term, and how the tribunal severely breached natural justice during evidentiary hearings.
Assalamualaikum everyone. For the second issue, let us examine whether party autonomy in international arbitration allows parties to set aside mandatory Malaysian law. Although Global Minor and Nusantara choose London as the seat, this freedom is not a license to violate Malaysian public policy. Based on Section 4 of Arbitration Act 2005, disputes that are contrary to public policy cannot be set aside. In the case of Calibri MNE Sdn Bhd and PT Kuline HVAC Engineering, the court confirmed that public policy includes actions that are detrimental to the public interest or violate basic morality. Global Minor tried to label this case as purely commercial, but the facts show otherwise. Toxic waste pollution, holding of workers' passports, and violence against communities are serious violations of Malaysian statute, not just commercial issues. In the case of Jan D. Nur Malaysia Sdn Bhd and Vincent Tan Chi Yon, the court held that an award that was manifestly unlawful and shocked the conscience of the court was unenforceable. Global Minor's action in polluting the environment and oppressing workers were acts that were actions that clearly shocked the conscience of society and violated our fundamental principle of justice. Therefore, the actions violated basic justice that is the core of our public policy. The tribunal in London did not exempt global minor from complying with the mandatory law of the country in which the project operates. In conclusion, party autonomy is limited by the existence of public policy. Under Section 37 of Arbitration Act 2005, the High Court of Malaysia has full power to refuse to enforce this award because it is contrary to the interest and sovereignty of the law of Malaysia. Thank you.
Right, so moving on to my part, I will present about the next question, which is whether the London Arbitral Tribunal's proceeding refusing to grant Nusantara's request for adjournment comply with the principle of natural justice and right to be heard under both English and Malaysian law. So to analyse the tribunal's conduct that was held in London, we look at Section 33, Subsection 1 of the English Arbitration Act 1996, where this section provides a statutory duty on the tribunals to act fairly between the parties to ensure that each party is given a reasonable opportunity to be heard, to put forward their case and to deal with the other party. So applying this to our case, the London tribunals was fully aware that Nusantara's key witnesses were legally bound by ongoing domestic investigation within Malaysia. So by refusing the adjournment, despite knowing this matter, the tribunal has basically breached their statutory duty because they stripped Nusantara's opportunity to establish their defence. The procedural unfairness of this case has worsened when the tribunal chose to proceed with a critical evidentiary hearing when Nusantara was absent. Under the case of Pancaran Prema Sendirian Berhad and Iswara Bena Sendirian Berhad, the court stated that natural justice is violated when a party introduce new material evidence without giving the opposing party an opportunity to respond to it. So to apply to this case, since Nusantara was absent from the hearing, the tribunal allowed Global Minor to take advantage of this situation by introducing new expert reports on causation and damages. So when the tribunal admitted these reports, they basically just unfairly denied Nusantara's fundamental rights to cross-examine this expert witness, which the tribunal later awarded Nusantara with damages entirely based on the unchallenged argument that was presented by Global Minor. Under Section 39, Subsection 1A, 3 of the Malaysian Arbitration Act 2005, it provides that the High Court has power to refuse the enforcement of foreign award if the resisting party can prove that they were unable to present their case. Furthermore, in Master Mulia Sendirian Berhad and Sigur Ros Sendirian Berhad, the court stated that to invoke natural justice, the party must prove that the breach was so serious and caused material prejudice, meaning that it would really affect the final outcome of the arbitration. Applying these rules to this case, we can see that the material prejudice is obviously established, as we have seen that the tribunal refused to adjourn, combined with their decision to conduct a critical hearing with the absence of Nusantara, allowed Global Minor to present their evidence without cross-examination, while Nusantara was completely silenced. If the tribunal granted the adjournment and protected Nusantara's right to be heard, maybe the outcome and damages would have been completely different. So we can see that the proceedings were obviously one-sided from the start. So to conclude, this breach of natural justice is obviously clear. The London Tribunal has been actively denying Nusantara's right to defence while leaving global miners' evidence completely unchallenged, while awarding damages entirely onto Nusantara. So since material prejudice has been demonstrated, Nusantara is fully justified under section 39 subsection 1 A3 of the Arbitration Act 2005 to request to Malaysian High Court to refuse the enforcement of this foreign award. So that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is NURAIDA bin LATIF. My number metric is 1222047. So the question is the possible ground liable under the Arbitration Act 2005 and the New York Convention for resisting recognition and enforcement of the foreign arbitral award in Malaysia. So the issue here is whether Nusantara Resources Sidang Berhad can successfully resist the recognition and enforcement of the foreign arbitral award issued by the London-seated LCIA before the High Court of Malaysia under Section 39 of Malaysian Arbitration Act 2005 as well as Article B of the New York Convention 1958. So imagine you are a Malaysian company and your projects get shut down by your own government because of a serious environmental and labour crisis, for example. Then a private tribunal sitting in London orders you to pay massive damages and tells you to keep operating anyway. Can they really do that? So our answer today is definitely no. So we are going to show you exactly how Nusantara in this case can use Section 39 of Malaysian Arbitration Act 2005, which directly also implements Article B of the New York Convention 1958 to successfully block and defeat or resist this foreign award right here in the Court of Malaysia. So basically, under Section 39, said that the High Court has the power to refuse enforcement. Yes, of course, the burden of proof is high on the party that resisting it, as shown in the Casa de Risbarmio case. But here, Nusantara easily meet this standard. Why? We based on several grounds. So the first ground is actually on total breach of natural justice, which falls under Section 39, subsection 1, paragraph A3 of our Acts, Arbitration Acts, which perfectly mirror also with Article B, Clause 1B of the New York Convention, which both laws protect a party who was otherwise unable to present their case. So whereby we can use the case of Master Mulia and Sigurus, where the rules is simple. You cannot decide a case or admit massive evidence without giving the other side a fair chance to speak. So if you do, it causes actual material prejudice to the other side. Even we look at what happened to Nusantara, they asked a pause because their key witnesses were locked in active domestic government investigations. Then the tribunal said no. They held the most critical hearing of the case in Nusantara's absolute absence. Yeah, to make it worse, Global Miner used that empty room to drop brand new expert reports on damages, and Nusantara actually could not cross-examine them, could not defend themselves, and could not submit documents. So this is clear violation of Article B, 1B of the Convention, which Nusantara was entirely blocked from presenting its case. Moreover, based on our second ground is that the tribunal went completely outside the scope of the contract, violates Section 39, subsection 1A IV04 of our Arbitration Act, as well as Article B, 1C of the New York Convention, which rejects awards dealing with disputes outside the agreed terms of submission. So we use the case of PT Asuransi that tells us that a tribunal acts completely without jurisdiction the moment it ignores explicit boundaries of or defense rules written into the contract. Yeah, Nusantara's contract explicitly stated that all activities must comply with Malaysian environmental and safety laws. Yet, the tribunal blocked all human rights and community impact reports, calling them outside a commercial scope. So, by clinically separating commercial claims from mandatory local laws, the tribunal effectively rewrote the contracts, isn't it? So, they judged a dispute they did not have permission to judge, as stated in Article V1C of the New York Convention. Finally, let's talk about sovereignty, non-arbitrability, and public policy. So this targets mostly on Section 39(1)(b) of our Act, which mirror also Article V2 of New York Convention. So under Article V2A of New York Convention, enforcement is denied if the subject matter cannot be settled by arbitration under local law. So this project was halted because of toxic water contamination, forced community displacement, and migrant workers having their passports stolen. So these are state's environmental crises and actual crimes. They belong to the police and Malaysian regulators, not a private commercial fraternity in London. So basically, they are strictly non-arbitrable. Furthermore, what we can see that under Article V2B of the Convention, an award will be rejected if it conflict with the public policy of the host country. As in the case of Caliber M&E, where Malaysia will reject any foreign award that shocks the conscience of the courts or harms the public goods. So if we think about it, if our High Court enforces these awards, it would be forcing a Malaysian company to break active Malaysian environmental laws. So that is basically an insult to our country sovereignty. To conclude, we can see that Nusantara actually has an open and shut case to block this award under both Malaysian law and New York Convention. Especially under Section 39 of Malaysian Arbitration Act 2005 and Article V of the New York Convention, as we discussed earlier. Thank you.